Folks, we're back. This is Steve Sampson, Stephanie Phillips with another episode of Veterans in Politics. Today we have Amy Mastin, Clark County District Court Judge, Family Division, Department M. We don't know what the M stands for. Mighty, maybe?
Mastin.
Thank you.
Oh,
yeah.
Mastin. There we go.
That's an easy one.
Our 7 o'clock show didn't make it, so we're starting this show early. Ms. Phillips.
Thanks for joining us, everybody. And thank you to our sponsors. We have Dr. Ari Nagy. He's running for Congressional District 3. His website is nagyforcongress.com, and that is F-O-R, nagyforcongress.com. Jump on his website and check out his platform. We also have Henderson's mayor, Michelle Romero. She's running for re-election. Her website is votemichelleromero.com. votemichelleromero.com. Jump on her website and get in touch with her. We also have Cody K. Whipple. He's running for Congressional District 4. His website is codykforcongress.com, and that is the number 4, codykforcongress.com. Jump on his website and check out his platform as well. Don't forget to grab your copy of Steve's book, How to Navigate Nevada's Family Court System. If you are a family court litigant and you don't have an attorney and can't afford one, grab this book. It is a self-help book. It will help you navigate that system. You can get a copy of this on Amazon. It is $14.99. Also, we have a merch store. It's vipimerch.com, vipimerch.com. There's all kinds of fun things for you to check out there. And also, don't forget to grab your tickets to our Valentine's Ball. It is February 7th, and it's coming up really quickly. Thanks for getting your tickets.
Yeah,
We're so happy you're coming.
Yeah, thank you.
So, everybody, it's going to be a great time. So grab those. You can get on veteransinpolitics.org, and the link is there for you to grab tickets. For my rant, I have to, this is going to take just a couple of minutes, but we were down Monday at the Clark County Government Center because our judicial candidates were filing, and that started Monday. We were down there pretty much all day for the most part, and when I got there at 7 and we got in line, and when we started filing, the judges were sitting there, some of them an hour, just over an hour. So because some of the scanners were not working properly, they had glitches in the system, they had technicians coming over and trying to fix that. I heard the discussion there. It was a new system, I believe they were working with. So they were trying to work out the kinks and the bugs and all that. But we had at least, I think, 4 candidates in there at the same time. So I was in there getting pictures, video during this process. So I go up to the entrance there where the candidates were coming in to check in. And this one particular judge, she had a trial coming up and she had to go. And I said, well, at this rate, I mean, they've been there for an hour nearly, and if you have to wait that long, you're going to be late for your trial. So you may want to come back. Well, one of the ladies that was checking people in, she overheard my conversation, which was a private conversation between me and the candidate there. And she said, why are you telling people that the scanners aren't working? Because I told this judge that was part of the problem and part of the delay. And I said, because they're not working. And she said she was highly offended that I was saying that these scanners were not working. So she goes and tells the supervisor down there, I think her name was Heather, but I'm not sure. Don't quote me on that. But anyway, she tells the supervisor gal. So she comes over and tells me, don't tell people the scanners aren't working. And I said, well, they're not. And that is the truth. So she's trying to tell me what to say and what not to say to a candidate that I'm representing, which first of all is none of her business. Secondly, I have a First Amendment right. I can say whatever I want to say. And that was the absolute truth. And yes, the process was like an hour or more for some of these. So anyway, she's trying to tell me what to say and what not to say. I didn't appreciate that. So we go over, continue filing, continue to take pictures. And then, I don't know, a half an hour later, the registrar of voters, is that what her title is? What's her name?
Lorena, I believe. I don't remember.
Lorena. She comes up and tells me motions for me to come over and talk to her privately. So I go in the middle of the room and talk with her, and she goes, what are you doing? here. She said, do you represent these? And I said, we have a consulting business. We are representing some of these judges. I'm getting pictures and videos for content because
Lorena Pertello.
She was very nice. She was not mean in her, what she said, but she wanted to know what I was doing, and which I thought was pretty obvious what I was doing. And she said that it was making her staff uncomfortable that I was in there taking pictures as if they have never seen anybody in there taking pictures with the candidate that is filing. And she said, how many more candidates do you have? And I said, well, we have one coming in this afternoon. And she said, well, when you're done, we would like you to leave.
So you were invited to the door.
I was like, okay. So meanwhile, her staff was uncomfortable, but they were posing for pictures. I saw another gentleman. He says, I'm going to be in every single picture that was taken today. Great gentleman. He was sitting in the back, kind of watching. Sweet guy. He didn't mind at all. Another one smiling. Everybody was in a great mood. It was a really great experience other than these ladies. But it was interesting to me that if they were so uncomfortable, why were they so happy, with these candidates and joking around and, anyway, none of it made sense to me. I did not understand what their problem was, but I would say Clark County, we, the taxpayers, pay for your salaries. We pay for the building that you work in. We pay for all this as taxpayers. So don't tell somebody that they cannot tell their candidate something of the truth that was going on in the process. That is wrong. So stop it. Okay, I'm sorry that took so long. I had to say, I didn't say it on the live when we were out front of the building the other day. I saved it for a rant. Sorry, Amy, but you were down there.
No, I was down there. The process is different from how I remembered it 6 years ago. It was substantially less efficient than I remembered it 6 years ago. And I attributed that to them working out the kinks in this new system.
Yeah.
And you're right. Everybody I interacted with, very lovely.
Weren't
Everybody
they?
was fantastic.
Mhm.
And I think she was the uncomfortable one.
Yeah.
I appreciated you being there. Thank you.
Thank you. And I loved your video turned out great. And the guy that was filing you, I mean, he was all happy.
Super guy.
Nice.
Yeah.
And I think he did have some problem with
He was
the
having some
scan-
struggles.
with even during your process. But we did go down there later because Judge Throne filed in the afternoon.
Yeah.
So by the time we got down there later on, they had worked out more of those kinks, so it didn't take as long.
Yeah, I figured as the day went on, it was going to get smoother.
Yeah.
Yeah, it's just a shame that they can't do a trial run or something and work those kinks out before we're all down there.
Yeah. But they were not happy with me. But we had multiple candidates in there at one time.
And you're not the only person who's down there in that role or in that function. It's a public building and a public process. So
And publicly paid for.
Got to.
Anyway. Okay. Thank you. Thank you for the time.
Thank you.
Well, thank you, Ms. Phillips.
You're welcome.
Judge Mastin,
Yes.
thank you for coming on the program.
My pleasure. Thank you for having me, Steve.
Absolutely. Could you give us a background?
How far back do you want?
Birth.
So I was born in Los Alamos, New Mexico.
Oh.
My dad was working at the National Lab there at the time, and lived in many states after that. Missouri, Pennsylvania, ultimately ended up in Florida after my parents' divorce, and spent most of my life down in Broward County, Florida. So Fort Lauderdale area, love it down there.
I love Fort Lauderdale.
Yeah, it's hard not to.
The water is warm, not like Miami. The water is cold.
Yeah, Miami is cold. I didn't even know that. I don't know that I've been in the ocean down in Miami, but love Florida. Went to Florida State University. I have two brothers. They were up there with me, the three of us together, and got my undergraduate degree in political science and English and public administration, and ended up pregnant.
Got a JD too, Juris Doctor?
Not at Nova. or excuse me, not at Florida State. I went to Nova.
Okay.
I was pregnant my last 2 semesters of undergrad, worried how I was going to take care of this baby I was having with a political science and English degree. There's not really like a, those aren't really marketable skills or marketable degrees, and decided that I wanted to go to law school and needed the help of my family. I was a single mom. And so I moved back to South Florida where my family was and went to Nova Southeastern, which is a private law school in Fort Lauderdale.
Okay.
And the day that I graduated, I moved to Las Vegas. Literally closed my eyes, threw a dart at the map. I knew I wasn't going to stay in South Florida. There are as many lawyers there as there are old people, and that is a lot. And the job market for lawyers was horrible. And I was ready for a change. Okay. And so ended up out here. And ultimately my mother and my stepfather, who were helping me with my daughter, they moved out here too.
Okay.
Let me see. What happened after I got here? Got a clerkship with Judge Hardcastle.
What do you think about it?
I cannot say enough wonderful things about that man.
Okay.
I consider him a mentor. He's brilliant. He really taught me how to think about the law. It was a privilege to get to work for him. It was a privilege to be liked by him. That's a status that's reserved for very few people, including
he doesn't like too many people.
No, he does not, including his law clerks. But
we got along.
Yeah, you know what? He's really discerning. He can see through people pretty quickly and knows who's genuine. So I have no doubt that he and you got along, Steve. But didn't pass the bar the first time that I took the bar. Okay. It was the first test I had ever not passed in my life. And when I say not passed, like if passing were here, I was here. Miles away. Terrible, really, because I felt like that I put, it was a tough few days. I mean, it's really brutal. I was still a single mom. Right? No, at that time, 12 months.
Oh.
So I had a whole nother year, not to mention like the process going through that again. I just couldn't, at the time, I was just devastated, had to pay more money, had to continue to work, at my lowly law clerk wages while it was going on. So it was devastating, but, I also believe that everything happens for a reason, and it just wasn't my time, and studied for it and took it the second time and passed. I was clerking for Hardcastle at the time. I worked at a law firm called Dempsey, Roberts and Smith. They're all JAG attorneys. Worked there after my 2 different stints with Hardcastle. I clerked for him twice. And got into dependency law, so child abuse and neglect, civil child abuse and neglect, and started sitting as a pro tem hearing master doing that. At the same time, I was working at a couple of different firms. Ultimately, I went out on my own. I have only ever practiced family law. Family law has been my sphere of legal knowledge since the minute I became an attorney, from
all
clerking.
Different areas of family law. Too.
All different areas of family law. I mean, family law is a broad category, so there's certainly enough to do in a 30-year career to learn family law. But yes, dependency and worked at the DA's office at one point doing abuse and neglect law also. So always family law, sometime in private practice, a lot of time working for the county, and then got appointed to be a hearing master in 2013. And that was to be a domestic violence hearing master specifically. Okay. Along with being a domestic violence hearing master, they call it commissioner now, thank God, because hearing master is like such a disgusting term. They should have done away with it, ages ago. But anyway, being a commissioner, means that you are also subject to be reassigned or signed additional roles at any time. And so during the time that I was a hearing master, I also did discovery commissioner work. I did minor guardianships. I ultimately sat as a child support hearing master for almost a year while I was campaigning last time. So yeah, ran the gamut as a hearing master as well. And then sought appointment to, whose seat was it? Judge Steele, maybe? I can't remember now. Judge Forsberg, whatever department that is. And it came down to me, Judge Forsberg, and a third person, and she got picked. And I decided at that point that I would run the next time the opportunity came up. And with all those new judicial seats, it was just a prime opportunity. So ran for election in 2020 with the 22 other new judges. And
So what motivated you to pursue a career in law, especially, why did you focus on family when you have all these civil, criminal,
a whole bunch of other ways that I could have made money.
Sure. Especially business law. You can make a lot of money in business law.
There are a lot of different avenues. So the real reason, really at the core of it, when I was seeking to start law school, I had to be involved in my own family law case. I was moving from Tallahassee, where my daughter was born, in northern Florida, down to South Florida. In Florida at that time, you couldn't move counties without permission of the court, which is really onerous there because there's, I think 150 counties in Florida. Anyway, so I was involved in my own family law case, and it changed the trajectory, of my life. If I didn't have a competent attorney and a wise judge, I ran the risk of not being allowed to relocate and start law school. And so obviously it changed things for me. And I realized how it felt to be a part of that process and be taken care of by somebody who had my interests and my daughter's interests at heart, So that's how I got into it and have a passion for it. I can't imagine doing something that I feel detached from. This is deeply personal. It matters to everybody who appears in front of me. And so it matters to me, and it makes the job worth doing.
Were you also in the DA's office?
I was. I did abuse and neglect.
And how would you, okay. Let me see if I could phrase this. You were in private practice for how long?
I off and on a total of, I think it was 15 years.
And then you went to the DA's office?
Went to the DA's office in between private practice, DA's office, and then back.
How long were you in the DA's office?
3 years.
3 years.
I don't know. Do you have my resume? I would have to refer back to it.
You
know more about me.
He has your background.
I'm like, what do you know that I don't know? 3 years, maybe.
So between private practice and the district attorney's office, where do you think you learned more of the skills to become a judge? Or is it a combination of the two?
Yeah,
or one
probably
stands
a
out more than the
combination
other?
of two. What's interesting, I have a belief that anybody can learn any area of law, right? Anybody can study enough, learn the law, and
the book.
Right. Well, the book and the two of you, you're certainly deeply embroiled in this. The process of learning how to be a judge is the hardest part of what we do now. It's such a nuanced job. So I think I learned both in private practice and at the DA's office from being in court on a regular basis, observing judges, knowing what I thought was valuable to litigants and what wasn't valuable to litigants. I'm sorry, I'm focusing on him because he's asking the question. And so I think just the process of being in court all the time helped, but certainly the on-the-job training of being a pro tem hearing master for years and years, and then working as a hearing master. I would say it took probably 3 years before I felt like, wow, I have this job down. And
Plus your own experience.
Yeah, exactly.
Life experience, you can't put a price on that.
Yeah, absolutely. But there's also, as a judge, you have to set aside that life experience,
True.
right? Because my life experience isn't necessarily the same.
You want to be neutral.
Absolutely. So that's part of learning to be a judge, is learning how to disregard your own personal experience, and how the world impacts you, and try and see it through the litigant's eyes. So that's hard work. I mean, it really does take a long time to hone those skills.
And you were on the bench about 20 years prior?
No,
how long were
from
you
2013 until I was
Okay.
elected in 2020.
Okay.
And then I've been on the bench since 2020. So don't ask me to do that math. It'll involve me using my fingers and I'll be embarrassed.
So when you're talking about how long it takes to kind of get comfortable with it, learn all of these things, it always has amazed me. Some of these judges, and these are civil, criminal, they're a civil attorney, but then they get a criminal calendar.
Right.
And vice versa.
Mhm.
And I've seen this where they jump into this. Not only are they haven't practiced that, you have been in family law the whole time.
Right.
So you being a family court judge, I mean, that just makes sense. Should the same way that doctors specialize in a certain area, should attorneys have to specialize in that area before they take the bench? Should they have to have a certain number of years specialized in civil, specialized in criminal, before they're even allowed to have that kind of calendar?
I mean, it would be ideal. The part about that, though, that I don't know that the public fully appreciates is it's out of our hands to an extent, right? So I had dependency, abuse, and neglect experience. When I got elected, it was my hope at the time that I would be able to sit on the dependency bench. I didn't get that choice. That's a decision that's made between the presiding judge and the chief judge. So the attorneys who are civil attorneys who are running for district court downtown might have an expectation or a hope that they get to sit on the civil bench, but that decision is not theirs to make. My reassignments or the various areas.
Chief judge and the presiding judge.
Yeah, all of that was told to me. I didn't say, hey, I've never done discovery before. I'd like to learn the complicated and convoluted rules of discovery so that I can adjudicate these cases.
Yeah.
I didn't ask for that. It's just they make that decision.
But shouldn't they
take that into consideration?
Yes, shouldn't they? Because you guys are there to serve the public, right? So wouldn't that serve the public better, more efficiently, when you have a judge that their background is in that particular area, right?
And I think that
we were talking to somebody the other day about
she's
that.
bringing that up because we had former Judge Stephanie Charter in here.
Yeah.
And she
look
was
at what happened to
juvenile,
her.
and then
Right.
she went to domestic, and she's like, I don't know nothing about domestic.
Right. Right.
Juvenile is my thing. You
No,
want to be there.
it's a challenge. And really for
no litigant want to be a guinea pig when a new judge comes trying
absolutely
to learn.
100%, right? Think about the impact it has on the public who's appearing in front of you. I got taken out of family law and thrown into juvenile delinquency.
Oh, wow.
The one area that I had never practiced in, never sat as a hearing master in, literally ground zero I was starting out.
You should go where your strength is.
I absolutely agree. So I spent a year and a half learning juvenile delinquency. I thought becoming really good at it. I love the interaction with the kids. I just fell in love with that area of law. And then I was unceremoniously taken out and put back in family court so that another judge could be brought into delinquency instead. And so I question the wiseness of those decisions also, but they're not mine to make. And I, have to trust, I guess, that there's people who know what they're doing, even if to me it doesn't look like they do.
Ms. Phillips?
The other thing too, that we have always wondered, I know the public wonders, gets confused. We were talking about reversals and that kind of thing. Can you explain because you guys, the statistics and the dings that go against you as reversals, that doesn't mean the entire decision was reversed. So can you explain how that works and what that process looks like?
I'm glad you asked because I think it's a complicated process. just the fact that you, and presumably most people who don't do this every day, view a reversal as a ding is unfortunate, because it's not. People who appeal decisions are doing a public service, as far as I'm concerned. Especially in family law, there is such an absence of substance in the way the laws are written. We had a shortage of family law cases until we got this intermediate appellate court. We only had the Supreme Court. People weren't appealing decisions. So you have this sort of broad and unspecified laws that we're challenged with how to apply those laws, right? And so we do the best job that we can and apply what we believe the law says to the circumstances. And sometimes we're wrong. Sometimes it'll go up to the Supreme Court and they'll say, I know that's how we've always done it, but this is how it should be done now. Or this is what the statute says, but this is how we interpret it when there's, multiple interpretations. And so it's not really a ding. Sometimes it's just a clarification. Sometimes it's just a difference of opinion, because they're not 100% right either. The other thing, one, I don't think it's a ding.
Okay.
And I think appeals are important.
People look at those percentages though,
They do.
and they say, "Oh, what's your percentage
Right.
on reversals?" And automatically, people think that's negative. If you have a high
Right.
percentage, you did it wrong. You don't know the law. I mean, on down the line, what people think. So
yeah, and it really doesn't mean that. The other piece of it is, like I said, I was moved from family law to juvenile delinquency and then back to family. So each time I do that, the cases that I've had are given to the new judge, and the judge whose cases I'm taking over are given to me. Somebody can appeal that judge's decision that was made 2 months or a month before I took over the case, but that reversal or remand is attributed to me. There's a huge civil case that's tied in with family law. I mean, I can't even, I get the pleadings on my desk. They are literally this high. I have no idea what the case is about. I've never touched the case, never had anything to do with the case. And it's one of the most hotly litigated Nevada Supreme Court cases right now. And I'm the reversal or the approval is going to be attributed to me when I literally had nothing to do with that decision. Senior judges, their decisions, if I have somebody sitting in for me, their decision can be appealed. That reversal, if it's reversed or remanded, doesn't go against a senior judge. It's attributed to me, and I had nothing to do with the decision.
Right. Okay.
So there's, I think, a misunderstanding fundamentally about the appeal process and what it means when they remand and reverse. And yes, it is also true. I've had a case where it wasn't just appealed once where it was upheld. It was appealed a second time, and they affirmed it again, except in the interim, to try and discourage ongoing litigation, I awarded attorney's fees at a motion hearing. So affirmed once, affirmed a second time, except they reversed this award of attorney's fees. They didn't like that I had done that. That's attributed to me as a reversal when all the substantive part of what I did was affirmed. The part that really matters, the part that made new law for the next judge. So I think there's an overemphasis on an appeal rate or a reversal rate. And I think it's important the public be educated about that. So thank you.
Yeah, no, I'm glad you said that, because that is very difficult to understand. There's a lot of moving parts in that. A lot goes on. I mean, just the difference between reversal, remand, affirm, and all these words that people, don't know.
Yeah.
So,
of course not.
We appreciate that.
I couldn't remember one of them. I said upheld instead of affirmed.
Upheld.
Yes, people don't know the words. I don't know the words.
I got another word.
Yeah.
Preempt.
Yeah.
So have you ever been, and
all the time.
How do you view that?
Well, first of all, we don't really know about preemptory challenges. We get a report.
You don't know about the first one?
No, we don't. In other words, it doesn't come to us. And
explain what that is, because a lot of people don't know what that means.
So a preemptory challenge, each side is entitled to one preemptory challenge which means before a judge has made a decision, they can say, I don't want this judge. They don't need to give a reason. They just need to pay the outrageous fee. I think it's close to $500.
$450. Could I stop you right there?
Yeah.
You said before a judge makes a decision. Isn't it before you appear in front of the judge?
No. It's actually before anything happens. There's multiple orders that we sign when a case gets assigned to us before the case ever comes in front of us. The one that comes to mind that I see most frequently, it's an order in forma pauperis, which is just the court approving that person can file a case without the necessary filing fees. If we've signed that is a substantive decision, and they can't preempt us after that. So it isn't just at the first appearance. It's before any order is signed. We sign sometimes ex parte orders, and those count towards making a decision. So does that answer your question?
It does.
Yeah. So each side gets an opportunity. They pay the fee, and they can get a judge removed from a case. Again, as a practitioner, I know there are a million different reasons a person might file a preemptory challenge. I might think a judge is more partial to allowing a litigant to relocate out of state, or less likely to allow a litigant to move out of state based on prior experiences I've had with that judge. So I might file a preemptory challenge and see if I can get lucky with somebody else. So there's a variety of reasons that attorneys make that decision. Sometimes it is just, I hate that judge. I never want to appear in front of her again. We don't see those preemptory challenges. We get a report once a month that tells us certain things about our caseload, the number of cases that we have, the number of active cases, the case type, et cetera. One of the categories of information they give us is number of preemptory challenges. I don't know until I see that report whether I've had any preemptory challenges in a particular month.
But the county makes a lot of money off those preempt challenges.
They do, and good for them.
It was like about $300,000.
Oh, I'm not surprised. Good for them.
Crazy.
Yeah, we waive filing fees for I would say 95% of the people who file cases. They have to get their money from somewhere. So if an attorney is willing to pay for it, God bless them. You don't know who you're getting. Right. And you only get one chance. So
and you could get somebody worse.
Yeah, right. You could be going from the frying pan into the fire. You really don't know. Mm-hmm. So there's a risk associated
How about
too.
recusal?
What about it specifically, Steve?
Have you ever been, anybody ever try to recuse you off of a case?
Often.
Oh, she says often.
Well, no, but again, there's context to all of this. And I think it's important that, that there not just be a reaction to the term or to the action. We look at what's behind it. Self-represented litigants automatically assume that if I didn't rule in their favor, and I don't want to say all of them, but this happens
You're
often,
biased.
That I'm biased. It must be about them. I've had litigants try and have me remove from a case a litigant. Actually, I'm not allowed to talk about it.
Don't.
Strike that. I can't.
Don't.
But
as long as you don't mention names.
Yeah. Well, so as
in general, not a particular case.
Hypothetically, a judge could have their campaign address at a certain P.O. box that also has 1,000 other P.O. boxes. Mm-hmm. And if a litigant decides that my P.O. box and the other litigant's P.O. box are too closely connected with one another, we must have a relationship with one another. I mean,
oh my goodness.
So it's, I mean, really, it gets to the point of ridiculous. So those are disqualifications. Those are decided by the chief judge. Recusal means I'm making the decision to get off a case. I only have one blanket recusal
on your list.
On my list. And then aside from that, I consider it my responsibility not to recuse from cases, especially those cases that are trying to get rid of me because they're difficult. I don't think it's fair to pass that off to another judge. And I think it's manipulation sometimes by the litigant. I just don't think it's fair to have a judge removed. And I think it's my responsibility to stay on a case that I've started, that I'm familiar with.
I found out last week that I'm on 2 appellate judges' recusal lists.
As a litigant?
Was a surprise to me.
Yeah, no, that is a
We have
surprise.
to find out why.
And it's my first, my middle initial, and my last name. They want to make sure they got the right guy.
Yeah, right. Just in case there's any other Steve Sampson up there with cases on appeal. No, that's interesting. And I think the general belief among the judges is that you want to minimize the number of recusals. Again, we all have a responsibility to each other to hear our own cases and not, have somebody else have to hear them.
So I know family court is tears at the heart a lot of times.
Okay.
So how do you handle emotional in a hostile courtroom?
Well, you assume I have a heart. And
We know you have a heart.
You have a heart.
You're a mom.
So I think if you can handle the world of child abuse and neglect, you can handle anything. There's some things that I saw there that are burned into my brain that I'll never be able to unsee that I wish I could. And you just learn to compartmentalize. So in terms of how does it affect me personally, that's a skill that I think all of us who practice in family law have to learn over time, right? As far as how I handle the high emotion in court that the litigants bring, I think you might be able to tell from my presentation here. I'm very matter of fact. And so my emotion has to stay out of it. I have to be the calming energy in the court. I have to be the voice of reason, the voice of calm. And so I think that's how I manage the emotions in court. I also think it's really important when I can from the bench, I try and validate everybody's experience there. I might not have agreed with your position. I might not think you have a good legal basis for what you're asserting, but that doesn't mean I don't understand the emotional reasons behind it and the emotional basis for what you're alleging. And so I think it's important to acknowledge that, and I try and do that in court and in my written decisions. I think that's a big part of it. And I think I learned a lot of that in domestic violence court too. I mean, people's experiences need to be validated, whether I agree with how they feel about it or not. It's not about me.
You were the hearing master of domestic violence. That has never happened before.
once.
Well, it might be one of my kids calling to say I need to stop talking with my hands so much. I don't know.
Oh no, that's all right. I talk with my hands all the time. I don't know who that is, but sorry, we can't answer the phone, guys.
That has never happened before.
Leave a message.
And look how late it is. We have never had a show this late before either.
But
People
who
know
even,
not to call me at 8:30 at night in my sleep.
yeah, but who even knows this number? Honestly.
A lot of people, because it goes on their text when they.
Oh gosh. Goodness.
In domestic violence.
Yeah.
What do you look for? Do you follow the chain of evidence when it comes to domestic violence? Do you believe in hearsay, accusations? Because some litigants will say, if you ask a litigant, "Hey, why didn't you file a police report?" and some will probably say, "Well, if I do that, my husband will lose his job and I have nowhere to go," and blah blah blah. How do you look at domestic violence when somebody brings that allegation?
I think it's one of the hardest things that we deal with down there. When I was a domestic violence commissioner, the amount of domestic violence training I underwent was critical to my execution of that job. I really needed to understand, and I thought I did going into it. I had a lot of experience in the world of domestic violence academically. But the level of knowledge that I gained through the courses that I took and by working with domestic violence advocates was critical to being able to do that job well. When I say the job of a judge is nuanced, nothing is more nuanced than sitting on the bench in domestic violence court. I think our court, frankly, I don't mind saying it. I've said it to them directly. I think they treat domestic violence court as sort of a throwaway court. I don't think it gets the attention and the respect it needs.
What does that mean, throwaway court?
I think it means, oh, we have an extra hearing master or we have a new hearing master. Let's throw them in domestic violence court.
Gotcha.
I mean, that is learning trial by fire. So I think that's unfortunate. How does a judge do that job? First and foremost, a judge is doing the job of applying the law, right? That is what we do. It's not about us personally. It's not about how we feel about what's in front of us. It's about applying the law. So that's how I do the job, is by applying the law. How do I tell who's telling the truth or who to believe? That's part of the hard part of being a judge. But I, on the domestic violence bench or in family court, would never say to a litigant, why didn't you file a report? Or it couldn't have been that bad. You never called the police, or you kept going back to him. I mean, I've had enough domestic violence training to know that those are horrible things to say to a victim. I know the answer to all of those questions, why a victim might not. And so I look for, in terms of in an evidentiary sense, I look for consistency between what they said here and here and here, taking into consideration the impact that trauma has on a person's ability to recall. But if there's vast inconsistencies between what they said at the time of the incident and what they're saying now, 2 months later, it'll call into question. I would not pretend to sit here and tell you that nobody ever lies about domestic violence. I think domestic violence advocates would want you to believe that and want the court to believe that. But some of the worst cases that I've ever been involved in were people using that as a manipulation to keep another parent away from the children. And so I'm aware that that happens. I'm not oblivious to that, and I look for that. But we all make mistakes. None of us get it perfect 100% of the time. An ex parte 30 or 45-day emergency protection order is just based on, did you have the requisite relationship with this person? And was there an act of domestic violence as defined by the statute? And if there is, the order gets issued. Period, end of story. There's nothing else to discuss.
And if they have weapons, they have to
They do have to surrender their weapons. They're not allowed to maintain guns. If they've been convicted of domestic violence, they can't. So yeah, I understand that there's an impact on the adverse party as well. But again, that's not what we're supposed to take into consideration at that initial phase.
So how do you weigh your discretion and the rule of law?
The rule of law is all that matters. Sometimes that law gives me discretion. Okay. And that's where I think my years of experience as a family law practitioner, my years of experience on the bench, I think that's where you learn to hone that discretion. So if there's a space to be filled in because the rule of law doesn't address it directly, that's where I rely on my experience as a legal professional. Again, not my personal experience. But does that answer that question?
Have you ever second guessed yourself?
Always. Always. We all do, right? We want to get it right. And these are emotional decisions. These decisions that we make stay with us for a lifetime. Again, going back to child abuse cases, there's choices that were made back then that I will question for the rest of my life. Some that were proven to be wrong because of the ultimate outcome, but we don't have a crystal ball. We don't know what's going to happen.
And as you said, there's a lot left to interpretation. Mm-hmm. Like when these appeals get made, their opinion may be different than yours, or they, interpreted this law differently. Yeah. It's amazing how much, latitude there is and
Yeah, the
room
law
for
doesn't address
interpretation.
all of it.
Yeah,
right?
it's not black and white.
There's every situation is so different, right? I've never seen the same case twice. So how it gets applied in each individual circumstance, again, that's part of what goes into those 3 years building your skills as a judge, before you feel like how you're doing you're doing the job well.
Are you known, do you have a reputation for being a judge that you favor the moms more or the dads more? Because I know some people say, oh yeah, this judge hates moms. This judge hates fathers or whatever. Have you heard? I've never heard that about you from anybody. And I just wondered if you have received that feedback at all.
Never gotten any feedback to that extent. I can say with absolute certainty that I don't favor anybody. I pride myself on my absolute neutrality. I don't care who your attorney is. I don't care who your mother is. I don't care if I used to be married to your son. I can be completely neutral. Again, that's one of those skills that you develop after an extended period of time. So I don't know what my reputation is, but I can assure anybody that there's no.
I personally, I've not heard anything negative about you.
I know you would tell me if you did.
Oh, absolutely. I would. I'd be like, Amy, what is that? No, I've not heard that. I've not heard, had any litigants, say about certain cases or decisions. But when we were observing, I think a couple months ago, I think we were in Judge Maxey's courtroom and she was talking about these informal trials, which I thought was very interesting.
Yeah.
And it seems like it's very welcoming to these pro se litigants, which are most of the people that go through there. So can you explain to people about those informal trials and what you think of that? And if you think that's more helpful to these litigants?
Yeah, I think that it's a godsend to the court and to the litigants. The formalities associated with a trial, litigating an actual trial. I mean, attorneys have gone to school for years to learn how to do it and then practiced for, their entire adult life to learn how to do it. We certainly don't expect that self-represented litigants are going to have that same skill set. We appreciate Judge Gordon so much for introducing this as a concept and championing the concept of an informal family law trial. It enables the litigants to do basically what they want to do. If you leave it up to their devices, this is exactly how they would structure family court. It gives them the opportunity to come in, say what they want to say. The judge has the opportunity to ask questions where we need areas of clarification.
But they don't get to ask each other questions?
Not in my court.
Okay.
It's a relatively unstructured process, so other judges may do it differently. But I think it helps minimize a lot of that friction. They can ask a question of them. In other words, ask them how the credit card got up to $10,000. Okay. So I might get that, but they're not interacting with each other.
Okay.
They wouldn't be at a trial either. You never want them interacting with each other. The less of that, if we could have them in two separate rooms, I would. So I think it's a very useful process. I give that option, certainly in every case where I have two self-represented litigants. I think attorneys who are willing to engage in that process when there is only one attorney, when they are the only attorney on the case, I think that's a very generous and reasonable thing for them to do. I think it allows the unrepresented party to have a little bit more confidence in the process when they don't feel like they're being out litigated by somebody or just bulldozed by somebody who knows what they're doing in there and they have no idea what's going on. So I think it encourages some confidence in the decision that's ultimately made. So I think it's a great thing. I think they're reevaluating it right now. If I remember correctly, they're going through the process of, okay, we're 6 months into this. How does this look for everybody? And I think there's just unanimous approval among the judges that we continue doing this. It's what we end up doing anyway when we have self-represented litigants.
What are the cons for the litigants that choose this route?
Sometimes people just need their day in court. And what I mean by that is it's not about the outcome. It's about being able to, again, say their experience, express their experience, have that validated in some respect by the court. And I think you don't really get that opportunity. It's much more driven by the judge. And those are the exact things that the court would like to avoid. So we don't get into all of that. Well, how did that make you feel, right? Or, tell me what a jerk he was on your wedding night. They might want to talk about that and feel the need to, share that, right? But that's not the part that we want to know. So it's much more fact specific and streamlined, and they don't really get to necessarily have their day in court from the perspective of this is how the whole thing made me feel, and this is why I hate him today, and now I've said my piece and we're all good. They don't get that experience. But I don't think there are any other cons, quite honestly.
Yeah,
I think it's just really beneficial.
Yeah.
Have you ever done a relocation or termination of parental rights?
Oh yeah, of course.
And what do you look for? Let's start with relocation. What do you look for in the relocation?
Well, it's driven by statute. So, and fortunately, that statute's been fleshed out recently. It used to be much broader and subject to interpretation, like we talked about. It's much more specific now. We also have a litany of cases that have given us some direction how this law should be interpreted. Always focus on the best interest of the child.
What does that mean?
Well, I'll get to that in a second. Before we even get to that point, though, the court has to they have to meet a threshold test that there's a good faith reason for the move and that it's in the best interest of the child from their perspective. Sensible, good faith reason for the move and in the best interest of the child. The best interest of the child, those criteria, those standards, what we're supposed to evaluate, that's been spelled out in statute for a decade now. And I think is pretty thoroughly explained now by the law and the case law. We're looking at the parent most likely to foster a relationship with the other parent, the parent most likely to allow ongoing communication relationship, the parent with the best mental, physical health, the parent, of course, I do it every day of my life. And as we're sitting here, I can't name all of them for you. But those factors are spelled out for us. And in every written decision we do, and they're like A through M. And in every written decision we do, we have to analyze every single factor A through M, which is why our decisions are 50, 100 pages long.
Poor trees.
But even when you go through that doesn't mean that it's in the best interest of a child to be taken away from one parent and allow someone to relocate just because, oh, I got a better job, or, oh, I want to buy this house, or, whatever. If you have two functioning parents that are both, able to take care of their child, both want to be with their child, I don't understand how these relocations sometimes are in the best interest of these kids when they're being taken from one parent. That's how I see
because
it.
Underneath all of it is the fundamental right of that parent to live their life also. And I understand it's all a balancing, right? We can't stop that parent from moving. So if a parent has remarried and their new spouse or the spouse they've been married to for 10 years now has a job transfer, they have no control over that. Military, it happens all the time. Those are our most frequent relocation cases. In fact, I can't tell that parent they're not allowed to move. The only thing I can decide is whether the child should stay here with parent A.
Like primary custody here.
Yeah, or be allowed to leave with parent B. I don't get to say, no, you don't move. You have to stay here together because that's the best thing for your child. And again, it's law driven. So there's a lot of things that happen in family court where your visceral reaction to it may be, oh my God, that's so wrong, or that's so unfair. Like, how does this person who makes $5,000 a month have a child support obligation of $1,200 a month? You might have a reaction to it. that's something to take up with the legislatures, right? Those are the people who tell us,
Make the formula.
right, that
Yeah.
we need to abide by. Our job is just to apply the law. I find relocation cases to be among some of the hardest that
Yeah.
we have to decide because
Yeah.
it is heartbreaking.
Yeah.
Most of the time, the parents who are there asking to relocate also don't want to have to do this to the child.
Yeah.
The ones who are doing it because they want to take the child away from the other parent, those are the ones that don't get to take the kid with them, right?
Yeah.
How do you figure that out?
Usually it's not that hard. I mean, some of these things that we're talking about are hard to determine, and I've acknowledged that. This is not hard to determine. You know, a lot of these people will come to court after litigating contentiously for 10 years over custody of this child, and then all of a sudden, right, they need to leave this state.
Mm-hmm.
So the less capable you are of getting along with the other parent, the less likely you will be allowed to take that child to whatever new state with you. That's how the law is written. You cannot be doing it with the intention or motivation of depriving the other parent of that relationship.
Like spite.
Right. And I've had those. I've had those
Oh,
that
I'm
I've
sure
had,
you had plenty of them.
to deny.
Mhm.
But again, they really are the exception. Most
Mhm.
people are heartbroken over having to do it.
Yeah.
So let's talk about termination of parental
Yeah.
rights. And before we get into that, because I have my own opinion on termination of parental
I'm
rights.
sure everybody does.
I think, my opinion, I think one person should not be the deciding factor to terminate somebody's parental rights. I think it should be a tribunal or a jury. I don't think
That's interesting.
I don't think one person should make that determination and tell a kid you'll never ever see your parent again.
Do you know what I think the effect of that would be? There would be many, many more terminations. Because I know the concept of termination of parental rights, when you look at it from the perspective of parents should be allowed to parent their children, it's easy to think that's what termination of parental rights are about.
Okay.
It is much more common that you don't have the evidence that you need to be able to terminate the rights of a parent whose rights should be terminated. That is more often what I see. And I think that if it were left to a jury, for example, jury of your peers, I think more people would be more inclined to terminate the rights because the law is really, 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 really restrictive. And I think it's counterintuitive a lot of times.
What do you look for?
Again, it's driven by statute. They have to have jurisdictional basis and they have to have a substantive basis. So there's two types of termination of parental rights. I dealt with it all the time in the world of dependency, where we're trying to free a child for adoption from parents who've not been able to kick their drug habit, not been able to stop whatever their violent tendencies are. And have not rehabilitated themselves. And the child's living with a foster family who wants to adopt this child and give it a forever home and stability. And this child never needs to worry again another day in his life where he's going to be waking up in the morning or whether he is safe, cared for, and loved. So that's one context for a termination of parental rights. And there are statutes that govern what the court needs to look for there. Failure of adjustment, just fundamental
Mental health.
unfitness, mental health.
Mm-hmm.
And really, even mental health isn't a basis to terminate parental rights because those are factors that are outside the parent's control, right? And again, those are circumstances where I think a jury would be like, yeah, that mom's never going to consistently take her meds. She's never going to be well enough to care for this child. You should terminate that parent's rights, but the law wouldn't allow that to happen.
Have you ever had to do that?
Terminate a parent's rights, yes.
It's a civil death. Is what
Absolutely. It is clearly the most serious thing that we do down there. But they're also not considered, so the dependency context is one context for where we do these. Now in just the general family court bench, you're talking about a parent trying to terminate the parental rights of another parent. So that's a completely different scenario. That happens very, 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 very infrequently. Have I had to do it? I have done it I can't think of a TPR trial that I've had. I know that I have one coming up, but it happens very infrequently. The terminations that you usually hear about are in the dependency context.
Okay.
So I don't think that I've done them since I've been on the family court bench.
Court observers, is your courtroom transparent?
Yeah. Tell me what transparent means to you. I've seen you ask this question.
You allow people to come in your courtroom and sit and watch.
We have to, right? So even if we're disinclined to do that,
so what
the
happens,
rules allow it.
What happens if an attorney, because I've seen it, looks around, Your Honor, I like to have a closed hearing.
You're not allowed anymore. It's just not allowed. You can invoke the exclusionary rule, which forces witnesses to be out of the courtroom during other people's testimony, but we're not allowed to just say, okay, you can be granted a closed hearing. And it is helpful that there has been such advocacy for all of our hearings to be open, because it means we don't have to exercise that discretion. It's not ours to make. The rule is we let everybody in. That being said, I don't let people in between hearings. I don't think I have an obligation to do that. If you're there to observe court proceedings, come in during court hearings. But when we're killing 15 minutes between a hearing, do I let people sit in the courtroom? I don't. I think optically it's bad if an attorney's sitting in the courtroom with the judge for 15 minutes before the other attorney shows up, I think it gives a bad appearance. So I don't let people in when we're not having active court. But aside from that, it's an open court. You all never come in my court. I've seen you there once.
Even court observers?
That's an invitation, by the way. Did you hear
Yeah,
that?
it absolutely is. I welcome you to.
Yeah, because that's interesting. So even court observers you don't want in your courtroom during that?
Absolutely not. No.
That's so funny.
No, there are such shenanigans that go on between me and the staff. It's incredibly inappropriate. No,
that's when we sit and chit chat with the judge. And
well,
the
yeah,
judge
exactly.
lets you in, that's a different story.
Yeah, no, absolutely. And again, you're not attorneys that would give this appearance of impropriety to somebody else who's sitting out there. But yeah, that's we need time to blow off steam between cases. We've been waiting for that litigant to get out of the courtroom so we can go, oh my God, she's the problem or he's the problem. So I don't think it's necessary for court observers to be in there when we're not having hearings, Well, I don't sit at
unless
your
it's
work.
us. I'm just kidding.
But I don't sit at your work and watch you do your job, except for the public part of your job.
So let's talk about enforcing court orders. How are you on that? When you make a court order, do you enforce it?
You took my question.
I
asked all the judges. Okay, never mind.
You go ahead and ask me that question, Stephanie. I'm sure you have something really important to ask.
I have two things I ask all judges, and that is one of them, because that really burns me, that these litigants get away with not paying child support for years and years. And, their remedy is to go to the DA's office. I forget the department. Every single litigant that has talked to us about going to the DA's office where they're supposed to go collect child support never happens. We get the most negative feedback about that department in the DA's office. Sorry, guys, but that's what we hear.
Steve, brush up on that.
Sorry, Mr. DA. But anyway, that just doesn't. So when you have a litigant, do you allow them to get away with not doing that or not dropping Johnny off at certain time? And, mom files and says, hey, he's not following these orders. I mean, how stern are you with this?
Let me address the child support issue. That is by far the busiest branch of the district attorney's office. Again, I sat as a child support commissioner, so I'm intimately aware of what happens down there and the process and how slow it is. You might be surprised to know we have one of, if not the most successful collection agencies in our DA Family Support Division in the entire country.
That is shocking compared to the feedback that we hear. That is amazing.
Well, so you're not going to hear the people praising, the district attorney's office for doing their job. What I tell people when I send them to the district attorney's office, there's a couple of reasons that I do it. First, I tell them it takes them a long time to get started. You need to contact them. I give them the number. I tell them you're going to make a phone call. It's going to give you a list of things that you need to collect and go down there and fill out your application. It will take a long time for them to get started. And that's just based on the volume of cases that we have here.
Why don't they hire more people?
It isn't that simple. First of all, it's based on federal funding. So the county can't even say we need more hearing masters down there. It's the federal government is the one that funds it. It's a completely separate budget we don't have control over. So that's one piece of it. Once they do get started, and this is the other piece that I tell litigants, they are far more efficient and far more effective at enforcing a child support obligation than a district court judge could ever be. They represent the interests, the DA's office, the interests of the child in collecting that child support. So they don't represent the mom, let's say, who might have custody when dad needs to pay child support. They represent the interests of that child in getting the child support. They will file actions for contempt when they're not paying on time. They will bring an obligor parent in every month and check the status of their payments on that child support obligation. I don't have room for that on my calendar. And for that to come on my calendar would require the litigant to file something every single time. I don't monitor my cases. They monitor a child support case. So you're getting negative feedback. And I don't doubt that it's warranted. Some people have bad experiences, but it is still far more effective to go through that process than to try and do it in family court.
I think it's especially probably skewed when the father happens to be an attorney that the DA's office is trying to collect from, because some of these people get away with years and years of not paying, and it's stunning to me.
Yeah, no, I have no doubt that there's circumstances like that. I will tell you there's even a process if the DA's office is too close to one party or the other. So, for example, one of the people working at the DA's office has a child support obligation that they're trying to enforce or have enforced against them. The DA's office doesn't handle that. That goes to the AG's office instead. So there's even a process for sort of segregating out any potential conflict. There's always going to be circumstances. The other piece of it, though, and I know this because I sat as an enforcement officer down there, you can't enforce what doesn't exist. Now, that obviously doesn't apply to the attorney who's not paying his child support obligation. But a lot of people are frustrated by having a child support order that says this person is supposed to pay $500 a month. But when that person comes in front of the child support commissioner and they're not working at that particular moment, or they just got out of 30 days in jail, my enforcement options are really limited. So I can only enforce what exists. And so some people are frustrated not by having an unenforceable order, but by the other party's failure to work and make their child a priority, like they have to as the custodial parent every day trying to make ends meet, right?
Yeah.
So yes, there's a lot about that that's difficult. As far as how do I enforce my orders or my willingness to enforce orders? I have a litany of lessons from Judge Hardcastle that will stay with me for the entirety of my life. And one of the things he taught me is never enter an order you're not willing to enforce. And I live and die by that. If I am entering an order, it will be enforced by me. People come in and they ask for behavioral orders. There are these fluffy orders that say things like, your girlfriend can't say mean things about ex-wife, or your mom isn't allowed to call.
Grown adults need behavioral order.
Right. But
All
people
the
ask
time.
me all the time, and I say no, because you are not going to then come back in and tell me how this person is violating the order. I'm not going to find somebody in contempt because their girlfriend said something inappropriate to the ex-wife. So my rule is I don't issue orders I'm not willing to enforce. What enforcement means might be frustrating to some people. But again, I am following the law. I'm not making my own decisions about what enforcement should mean. For example, do I think that somebody should go to jail? I'm trying to think of an example. Somebody should go to jail because they, I don't know, failed a breath test. No. I mean, enforcement should be reflective, BAC test, a blood alcohol test. I think enforcement should be driven by a remedy that addresses the problem, not just to show enforcement power. I think it needs to still be relevant to what I'm trying to accomplish. But I've gone so far as to transfer custody to the other parent when I have somebody who just repeatedly violates orders allowing for contact between child and that parent.
We hear that. Some of the most frequent things that we hear is that the judge ordered this and they're not doing it. And, a judge ordered child support and they're not doing it. So we do hear that a lot. But the other thing I always ask, especially female judges, do you have a CCW and do you carry behind the bench?
I'm not going to give you the answer that you want.
Okay.
I've never touched a firearm in my life. Never seen one in person.
Oh my gosh.
Nothing to do with firearms. That's just the family that I grew up in, and that's just how I live. So no, I don't question anybody's, choice to do that. And I understand why some judges feel the need to do it. Mm-hmm. I have the utmost confidence in my marshal. She's amazing. And I trust her to handle situations that need to be handled that way. It's not my job.
What about when you're on the streets and somebody recognizes you?
You know what's amazing? I can have an hour-long hearing with someone, Steve. They walk out the door. They have no recollection of what my name is or what I look like.
Oh, wow. Have you run into litigants like shopping and you recognize them and they don't?
It's such a small town, right? You would think it happens all the time. I can't say that I have. It's funny, my marshal runs into people that recognize her because she worked up at Spring Mountain Youth Camp for ages. People that, she had custody of when they were 13 recognize her 10 years later.
Wow.
But no, I haven't had that. I have had many dangerous situations where the FBI has become involved or local law enforcement has been involved because of threats from litigants.
You've had
against you.
I've had litigants. I've had a litigant, an extremely dangerous man, in my opinion, post my residential address on his.
How did he even get that?
Everything can be found.
Wow.
Unfortunately.
I could find it.
He could look it up right now. Yeah.
Split.
Yeah. Unfortunately, there's really just no privacy anymore, right? And so it's a private address, but that doesn't really mean anything.
Yeah.
But yeah, I mean,
That's
it's a
scary.
dangerous job, and we hear about the danger of the job all the time.
Yeah.
Let's talk about contempt of court.
Mm-hmm.
Have you ever fined anybody in contempt?
Yeah.
And have you pursued them with sanctions or incarceration?
Again, I look for the remedy that's going to effectuate whatever I'm trying to accomplish. So it is more often than not true that incarceration doesn't really solve the problem. It doesn't solve the problem for the party who's trying to enforce the order either, right? Me throwing somebody in jail for 10 days isn't really what they want. They
Some people
just
look at it
want
as a vacation.
they just want the person to do what they're being told to do. So I look for the remedy that's going to effectuate my orders or make them want to effectuate orders. Incarceration is an absolute last resort, and it's a civil remedy in family court, which means that there always has to be an out to it. And again, it's hard not to talk about cases. I forget that this is a public thing, but I can't speak about personal or cases that I've had personally. But I always do look for the remedy that's going to effectuate the change. In domestic violence cases, it's much more likely that incarceration is the remedy. Sometimes, a dangerous person needs to know that they're not the one wielding the power. So,
about vexatious litigants, and before you answer, do you think some attorneys should be charged with that?
yes, to the latter, 100%.
There's one in particular.
No, it's. It definitely exists. There's a process for identifying somebody or characterizing somebody as a vexatious litigant. It's not just somebody who repeatedly files motions. I haven't had to do it yet. I'm on the brink, I think, of doing it in one case, but it is an entire process and the point of the process is to give the vexatious litigant an opportunity to again have their side heard.
Could you explain that so they'll know
Explain the process. Vexatious litigant means somebody who maliciously and repeatedly files motions or litigates. They're using it as a weapon against somebody. And that's really where I think we have
weaponizing the court.
Where we have a responsibility to say, you're not going to use us as a tool to get back at the other person. And so we go through a process where they have an opportunity, they have notice and an opportunity to be heard. They understand what the court is looking at and why the court believes that they are vexatious or malicious in either the volume of their litigation. Somebody really wants to talk to me. Hello, caller.
Is that Andre? Does he want his shout out? Because I don't see him. I don't know who that is. Just take it off the hook.
I was going to do that, but that'd probably be rude.
So anyway, there's a process. I haven't had to do it yet, but I can see where it's necessary.
There's something about your aura, because we've never had that phone ring, and we've been in here for
forever.
Over a year.
It's probably the guy who published my address online.
Oh, yeah.
Right. Please continue.
I think that's all that I have to say about it. I haven't had to do it. I can see where it's necessary, especially in family court cases where, again, it's sometimes used as a weapon.
Okay. Have you ever had to scold an attorney in your courtroom?
Yes.
Okay.
Yes.
Okay.
Sometimes just as part of keeping control of the courtroom. Mm-hmm. Sometimes because I don't appreciate their tactics.
How about sanction? Have you ever had sanction?
I have not sanctioned an attorney. And again, to me, that's a remedy of last resort. I think it loses its effectiveness if it's something that you threaten and don't do. And I think it loses its effectiveness if it's something that you do
what do they have
every
to
time.
Do? And I mean, what's that threshold before you slap a sanction on them?
Well,
Or her, yeah.
An attorney can be held in contempt if they're inappropriate in court, if they're contemptuous towards the court. I haven't had that circumstance either, but that comes with sanctions. And then there's some rules that mandate sanctions, some federal rules that mandate sanctions. It's mostly related, frankly, to discovery issues. So are you more thinking about the attorney's behavior or their litigation strategy that I should be concerned with, I guess? What are we talking about?
Well, some attorneys can be very contentious and, have attitudes and think that, they're above everything.
Make allegations against the judge and opposing counsel.
I haven't had that happen, quite honestly. I mean, I know there's some attorneys like that out there. I haven't experienced that.
That's what started me going into family court.
Oh, really?
was an allegation an attorney made against opposing counsel with the judge.
Yeah, and that's unfortunate because I think it does a disservice to the entire process. People need to believe in the legitimacy of the process. I think that's part of what you two do down there, is help legitimize the process by pulling back the curtain, letting people see what's going on. And I think it is unfortunate if an attorney who is part of this whole process seeks to undermine that legitimacy. But I haven't had that happen.
Okay.
There's also, we have noticed, not just in family court, but other courtrooms, or, some judges get this notion, and maybe it's because they've been on the bench for a while, or sometimes they forget that they are public servants.
Mm-hmm.
And,
Name names, come on.
as soon as we're done, just kidding. But, we have noticed they forget. And I think sometimes, and it's not often, we have a lot of great judges on the bench, but sometimes they get egotistical. They think it's like their seat, their courtroom, which it's the public's. And so when we go down and observe, and sometimes it's may not be favorable, or, whatever it is, some of these judges think that they're entitled to that seat after they've been there for so long. And it's interesting. We've seen that, and then sometimes they get thrown out, and the public doesn't elect them. But I
it's
like,
not an entitlement by any stretch.
no, and the fact that you encourage the transparency, you encourage the court observers, so we can tell people what our experience is.
Yeah.
When we go down there, and that's important for people to understand what happens. And it is our courtroom. It's the people's courtroom.
Yeah.
And you are, doing your job of administering the law, and all of that. So I appreciate the transparency, and that you encourage.
We have a responsibility to maintain control of our courtroom. Mm-hmm. So I do refer to it as my courtroom.
Yeah.
I expect a level of professionalism and decency and courtesy when people are in there. And that's not because I feel like I'm entitled.
Yeah.
But I do also think that is an important part of the process. Yeah. I think part of what has happened in the 30 years that I've been doing this is there's been sort of a watering down of the respect for what we do down in court, and the integrity of it, and the formality of it. There's a reason that we put robes on, and that we have benches that are higher up.
In England, they wear wigs.
And why they wear wigs, and thank goodness we don't
you
hear
want the wigs?
all those
We
some
can get those
days.
to you.
Yeah, I was going to say it might be a benefit. It certainly helped me get out of the door faster in the morning. But, I think having an air of control over what's happening in there is important to the process also. Right. And I think facilitating that respect is important to the process too.
Mm-hmm. I agree.
How do you see yourself in these? I'm going to name the two circles. You got the legal community,
mm-hmm.
and then you have the public. How do you see yourself in the legal community, and how do you see yourself in the public?
I don't see myself in either place, because since COVID, it's really hard to find me out of my office at any point. One of the unfortunate parts, I think, of the job is that you lose that connection, that personal connection with a lot of the legal community, right? I'm not one of them anymore. I'm treated differently, and that's out of necessity. And I respect that. It's not personal against me. And again, it is important that some of those relationships I had before no longer exist. I love our legal community. I love the family law bar. And
Pro
so
bono project,
all of that. I like being a part of that. Public, I am fortunate in that the majority of close relationships that I have, people that I've been friends with for 30 years now, have nothing to do with the legal system. And that's refreshing. We're not, going out and hashing out cases. It's not about that. So my personal life, my life aside from sitting on the bench, really is far removed from anything associated with the legal profession. I like it that way.
Well,
did that answer the question?
Yes, it did.
Okay.
Do you have anything else for Judge Mastin?
I don't think so. I think we got the important things.
Do you know any other language besides English?
No.
Okay, just try.
I've tried. I'm one of those people. I can't do math, and I can't learn languages or play an instrument. I guess it's a pretty long list of things. I can't, directions, terrible at that.
Well, Judge Mastin, we want to thank you so much for coming on the program.
I've really enjoyed it. Thank you.
And we wanted the public to see the human side of Judge Mastin.
I think that's a valuable service also, but I think this process is really valuable. I think the more information the public gets about what we do, how we do it, why we do it, helps us. It makes our job easier the more people understand. And communicating that information to the public is really hard. So to the extent the two of you have done it effectively, thank you and keep it up.
Mark's going to zoom in on you, and this is your moment to shine. You can say whatever.
Oh, I wasn't prepared for this.
Come vote for me.
Oh, come vote for
I'm
me.
running
Come vote for me.
re-election.
Your website or whatever contact information you have, or your Facebook page or whatever it is.
Come visit me in my courtroom.
Direct or whatever you want to say.
All right. I am running for re-election in the hopes of retaining my seat. Department M, Family Court. You are welcome to come down and visit anytime that I'm hearing cases. My website, my Facebook site that these lovely people set up for me is Judge Mastin.
Judge Amy Mastin.
Judge Amy Mastin, thank you.
Mm-hmm.
And I'm hopeful I won't have an opponent. But if I do, I hope that I've earned the public's support with the work that I've done, not just the last 6 years, but for the 8 years before that I also sat on the bench and worked as a public servant. I take that seriously. It means a lot to me. So I think that's it.
Thank you, Judge Mastin.
Thank you.
Thank you, Ms. Phillips. Folks, that's Amy Mastin, Clark County District Court Judge, Family Division, Department M for Mastin. And we support Judge Mastin on the bench for another 6 years. And she's very knowledgeable. She cares about her litigants that's before her. She cares about the process. She loves the law. And she's been treating families very, very nice down there at Family Court. We haven't personally heard anything negative against Judge Mastin as far as Family Court's concerned, or anything for that matter. And we hope that that Judge Mastin stays in the seat for another 6 years to serve you, the people of Clark County. This is Steve Sanson, Stephanie Phillips with Veterans in Politics.
Oh, that was great.
Until next time.